now resume.
Good morning, Mr. Commissioner. Welcome back, and we are commencing our final submissions in this inquiry today. I have a couple of housekeeping matters. It's Wendy Baker for Commission. We have a couple of housekeeping matters to review this morning. First, our truly housekeeping, which is just some information about the room we're in. You'll notice that it's very small compared to what we've been used to, so we have had to ask people to work with us to find space in the room. I want to thank all the parties for helping me out in that respect earlier this week and last, trying to understand how many people would be in the room. Because we don't have the gallery space that we had in the previous room, I just want to remind everybody on the record that this proceedings are being audio cast from the Cohen Commission website, so people and their clients can listen if they can't be present in the room. To allow as much space as possible for people or for council, for the participants to have seating, we've moved Commission council up to the front beside the Commissioner, just so everybody understands why we're there. It's simply because of the seating problem in the room. And one last housekeeping matter, the mics that you see in the room, in our previous room, you'll remember that you pushed a button to turn the mic on. In this room, the mics are on, and you push the button to mute them. So it's going to be a bit of a challenge, and people need to be careful. And Mr. Lunn actually controls whether the mics are on or off, so I think only the speaking mic will be turned on for the most part. We'll try and manage that, but if you do need to stand up to make a point when you're not at one of the mics that's turned on, just give us time to get the mics turned on. And if you are at a speaking mic, remember to mute if you don't want the conversation to be heard by all. The Blackberries that people have with them, if you're at a mic, you must turn it off completely because it will interfere with the mic and the recording. So please be very careful about that. If you have a Blackberry with you, turn it right off so that we don't have that problem. Mr. Commissioner, I wrote to the parties earlier about the housekeeping matters that were on the table for today, and just to run through the list that I have still. There were some qualifications of experts outstanding from the hearings, which I'd like to deal with first. Then there are two documents, the WSP review and the MSC audit, which are in draft form, which I'd like to mark and make some submissions on the final documents when they're produced. I understand Mr. Taylor has a submission he'd like to make on some of the content in the reply submissions. Those are the housekeeping matters. I've set aside 90 minutes for that, and we're 10 after 10 now, so I'll take that down to 80 minutes. And I'll get started. First of all, Mr. Commissioner, you'll remember when we were doing the hearings on gravel mining in the Fraser River, we had two experts, Dr. Rosenau and Dr. Rempel, testify, and I made submissions on two sets of qualifications for these witnesses. One of the qualifications was objected to vis-a-vis Dr. Rosenau by some of the parties, namely the province, Canada, and Council for Stolo and Shiam, and you ruled that we would deal with this later in final submissions. So I made a submission on October 17 to Council seeking to have the two witnesses qualified in the one area which was not opposed by the parties during the hearing, and that was as experts in freshwater fish habitat in flowing waters and rivers, with an emphasis in the Lower Fraser. I've been advised by Mr. Tyzik for the province that he has spoken with Canada and Council for Stolo and Shiam, and they're content with that qualification, and I've heard no other objections to that qualification from my friends, so I would ask that those two witnesses be qualified as I've just described.
Very well, thank you.
And then Dr. Ken Ashley testified on June 14 as part of the wastewater hearings, and Council for the Commission led evidence on his qualifications in environmental engineering, aquatic ecology, and limnology. There was no objections taken by Council for the participants at that time, but there was an oversight in that the actual qualification was not asked for from you, and so that actual qualification has not been made on the record, so we're asking that that be made as well.
Thank you.
Thank you. And the final housekeeping matter from my perspective is two documents that were referred to in evidence and came in following the close of the different hearing topics. One of them is the draft performance review of the wild salmon policy prepared by Gardner Pinfold, and that's on the screen now. That's dated September 2011. And we understand that a final document will be coming as well. And then I'll identify the other document. The next document is an audit prepared by Intertech Moody Marine under the MSc program. And is that document on the screen? There we go. This is dated October 2011. Again, this is a draft document. What we would like the Commissioner to do with respect to these two documents is have the drafts marked as exhibits now, and then I would like to ask the Commissioner for a ruling that when the final documents are submitted to the Commission, that they be marked at that time and of course circulated to all parties and put on the website so that we have the final documents. They're just not available yet. I don't know what people's positions are on these documents. I haven't heard, so these documents are certainly were referred to in evidence as forthcoming. They're here. People have had access to them and understand we'll be relying on them to a certain extent in their submission. I would also propose that when the final documents come in and are marked, that the parties be given an opportunity to make a very short submission if they say it's necessary to simply address any changes in the final documents from the draft documents to the extent any of those changes affect their submission. So not a full submission on the new document, but just to address changes. So those would be the rulings I'm looking for on those two documents, and I don't know if people have a response to those submissions.
Yes, Mr. Commissioner. It's Canada's position. We're not opposed to these being marked as exhibits. We note that they are drafts. We'll note that there is a process happening between DFO and the authors of these two reviews, and when they are finalized, we agree that they be marked as an exhibit at that point in time, and Canada will provide a response to the final submissions at that time.
We agree with the proposal on behalf of the province. Cliff Krause for the record.
Thank you. And then the final housekeeping matter before we begin.
Should we mark this?
Yes, please have those marked.
It's a draft performance review of the wild salmon policy, exhibit 1992, and the draft surveillance report of BC commercial sockeye salmon fisheries will be 1993.
And we also have the ruling that we can mark the finals and allow submissions on the finals when they come in, Mr. Commissioner?
Yes.
Thank you. The last matter then is a motion or an application or a housekeeping matter that Canada would like to address. So I'll turn it over to Mr. Taylor.
What this is about, Mr. Commissioner, firstly Mitchell Taylor, and with me is Tim Timberg for the participant Canada. What this is about is some paragraphs in the replies received last evening of the Conservation Coalition, the Aquaculture Coalition, and the HELSIC, the Tribal Council, and I'll come to the specific paragraphs in the course of speaking. Those paragraphs by those participants refer to information that's not in evidence. Specifically, it refers to infectious salmon anemia, or ISA. And further on that, yesterday, all participants' counsel were advised that in one way or another, the Commission is going to have some reopening of evidence and some day or days of hearing of viva voce evidence, as I understand it, and some documentary evidence sometime in the not too distant future. There will be evidence at that time, of course, but right now we have replies that refer to variously media articles and various documents that are not in evidence, all of which are cherry-picked and snapshots and so forth. And because of that, and because the replies in the normal course will go up on the Commission's website and become public documents, and by putting this stuff in the replies, the participants in question can avoid the undertakings of confidentiality if they're allowed to maintain those submissions. I'm asking that the particular paragraphs that I'll enumerate be ordered struck from the replies in question, that those replies not be posted on the website, and that the participants be directed that they have to file new replies in accordance with any order made. The paragraphs in question are in the Conservation Coalition, paragraphs 19, 33 to 35, 40 and 41, and recommendation J, which is on page 38 to 39. In the Aquaculture Coalition, it's the first two sentences of the second paragraph on page 4. And in the Helsick reply, it's paragraphs 23 to 26. And again, because those paragraphs refer to material that's not in evidence and therefore should not be brought before the Commissioner on argument, and because it is particularly controversial material, presumably aimed, amongst other things, at grabbing headlines, and because all of this, that specific topic is going to be the subject of evidence, it's wrong, premature, and out of bounds to have it in the replies now and should be struck. The replies ordered not put on the website and new replies filed, as I say. Thank you.
Mr. Commissioner, Alan Blair, appearing for the BC Salmon Farmers Association. We support the application of Canada.
Mr. Commissioner, Callan, C-A-L-L-A-N, initials T-E, appearing on behalf of Her Majesty the Queen and Ray, the Province of British Columbia. The province agrees and supports Canada's proposal on striking the submissions with respect to the new issues that are not in evidence at this time.
Good morning, Mr. Commissioner. Welcome back. Lead of initial T appearing as counsel for the Conservation Coalition. Firstly, I want to clear up something that I heard Mr. Taylor say, that this was a breach of undertaking, including these materials. I can assure Mr. Taylor that none of the materials that were disclosed by Commission were disclosed in the context of my submissions in reply. So I take issue with his characterization of the paragraphs in that sense. I do make the admission that within the reply paragraphs, there is a reference to a newspaper article and information that has been widely disseminated and is made public through the press and other sources of media, that there was discovered in British Columbia ISAV. And on that basis, and without knowing, I should mention and hasten to mention, Mr. Commissioner, that there was going to be a process unfolding in this commission to deal with that particular piece of evidence. I was faced with the challenge of trying to answer submissions from Canada, the province, and the BC Salmon Farmers Association that relies heavily on the fact that there has been no discovery of ISAV in this province. And with respect, it is premature for my learned friend to make the application that he's made. I understand from a letter that I received from Commission Counsel from Mr. Wallace that he's proposing that we meet on Monday morning to discuss this very issue and what will unfold in terms of the hearings. But in the interim, what I'm faced with is this situation, that I have submissions of Canada, the province, and the BC Salmon Farmers Association that rely heavily on facts that are, as I know them now, to be inaccurate. And I am faced with the unenviable task then of responding to those facts, knowing full well that those submissions cannot possibly stand. And it was that, with that in mind, that I attended to filing a reply in the manner that Mr. Taylor describes. Now, we're all at a loss, I can imagine, Mr. Commissioner, because I don't have my reply submissions, and nor do you have the benefit of having them before you. So I would suggest that before you could even make a substantive ruling on this, you would need to at least review what's in the material and come to terms with it in that fashion. Those are my respectful submissions.
Mr. Commissioner, Greg McDade for the Aquaculture Coalition. As I heard Mr. Taylor, I've just been accused of drafting a document that's a breach of confidentiality and a breach of undertaking and an effort to grab headlines. The sentence says this: recent testing suggests that ISA is found in multiple species of Pacific salmon, including sockeye, in British Columbia waters. At present, the extent of ISA in BC is not known. That's what Mr. Taylor makes that kind of allegation based on. Today, I read a press release from the Commission that says testing of samples from Pacific salmon from 2 areas of the province has indicated the possible presence of the infectious salmon anemia virus in several Pacific salmon. There is nothing in the sentences in my reply that is any more offensive or unreasonable than the sentence in the press release. This is nothing more than a blatant attempt by Canada to yet again suppress evidence that's absolutely critical, to avoid, deny, whenever they can. This is, the government of Canada has entered into kind of a Alice in Wonderland area. I see only what I choose to see. And we pretend that stuff doesn't exist that everyone in this room knows to exist. I join with Mr. Leadham in saying simply that this motion by Mr. Taylor certainly has value in showing where Canada comes from in responding to this. In the midst of an international clamor over this ISA testing, rather than deal with the evidence, Canada wishes to ignore it. But it's premature. If there is going to be a hearing on these matters, there's nothing in those 2 sentences I read to you that is the least bit offensive, and certainly the appropriate way to deal with this is just to leave this motion stand where it lays until you hear that evidence. There's nothing controversial in those 2 sentences, nothing different than what the Commission itself is saying, and to strike them at this point would be to endorse that attitude of suppression and denial from the government. So I simply suggest that this application be adjourned until we have our hearing dates in December and hear the evidence.
Lisa Fong for Hiltzik Tribal Council. I support Mr. Leadham and Mr. McDade in that the application should be adjourned until December when we address the ISA issue. But I do want to address a few matters which were raised by Canada. I think it's important to know that in terms of timing, our reply submissions were actually due before Commission Council announced to us what the process would be to deal with this ISA information that was disclosed after the oral hearings. So all the parties, not just us, but everyone was at a loss as to deal with how do we deal with this issue, because we're filing our final reply submissions. And we had been told earlier by Commission Council that we have to have everything in our reply submissions because this was, in essence, the last chance unless there was going to be a further allowance. Now, as it turned out, Commission Council advised us, I think it was yesterday, almost 5 o'clock, that there is this new process that we will be able to, and I'm hopeful because Hiltzik is the Central Coast nation which is affected by where the ISA has been found, that we'll be able to tender new evidence and make further submissions on this very important issue. And I want to be clear because I think we are the, and I admit this, we are the guilty party. It was done absolutely without intention of mentioning a media release. And I say it's done absolutely without intention, and we would be agreeable to striking that 1 sentence or those 3 words in our submissions and providing the reply again. I want to be clear that there was absolutely no intention to breach an undertaking or to cherry pick or to do anything in the public media. We have had very contentious issues as Hiltzik throughout this proceeding. We have never behaved in that way, and we are absolutely opposed and terribly insulted by how Canada has characterized this behavior. Now, in terms of timing, again, I think it's important to note when Canada raised this objection, it was raised at 9:05. That's what we received it this morning. I didn't see it until I got in, and had I been able to talk to Canada in advance, we might have been able to deal with this in a fashion that didn't take up time in this hearing. And I think that would be an appropriate way. But in any event, I agree with Mr. Leda and Mr. McDade that this is a matter that can be dealt with at the hearings. Thank you.
Good morning, Mr. Commissioner. It's Brenda Gartner for the First Nations Coalition. I'm not going to speak to the substance of the matter, but I am going to speak to the process. If they're only referring to news presses that have come out and are in the public record, I can't see any problem with that if that's what they had to rely on to bring a matter of serious concern to you in their replies. And it is a matter of serious concern. This is not a light matter, and I'm sure you know that. And so if that's all that anyone is relying on, that is over and above the evidence, then I'd like those paragraphs to stay, and I'd like this to be part of the public record. We need all of the submissions of all of the parties and their replies part of their public record as soon as possible. People read them all over the province. My clients read them from your websites all over the province. And we need to continue our work in collaboration. People need to see what people are saying about these matters. And so to the extent that someone's adjourning an application until some further time, if that included these replies not being part of the website or waiting until that moment, I'm not in favor of that. I think it's very important that we move on with all of the information as part of the record. And so I'd encourage you to do that. And if something needs to, if they're only relying on a public document, there's a lot of people in their replies, Mr. Commissioner, who have relied on things other than what's in evidence. And so that this one public announcement that's a press release has caused so much concern is, I think, inappropriate.
Deal with them in reverse order, these submissions, that is. I'm assuming that Ms. Gartner hasn't read the paragraphs that I'm speaking to because she doesn't quite have it as what those paragraphs say. I will say that in my read and in my submission, the Conservation Coalition and the HealthSec are the worst offending paragraphs of the three. The letter that came from the Commission yesterday about how to deal with a newly arisen piece of information is very clear. So to the extent that Mr. Leadham is waiting for Monday to find out what will happen, we don't need to. Monday is the detail, but I'm going to read the letter in part. This is a letter from Commission Counsel to all participants. The Commission will convene an oral hearing restricted to this topic. And it goes on to speak to when they think they're going to do that. Obviously, they're scheduling issues, but they're aiming for December. The topic in question is ISA virus hearings, and the Commission letter was, in my view, appropriately worded. It's also something that only Council gets, and I'm not going to read it all, but it was appropriately worded and neutral. To the extent that there is a Commission media release, which I haven't seen, that says what Mr. McDade says it says, in my respectful submission, a Commission media release has gone too far. But Commission Counsel's letter was fine. In any event, the real point is that there is going to be a hearing on this. That's when you get evidence, and it's after that you make submissions, not now. The idea of adjourning and leaving everything in limbo doesn't help because you still have, and I'll use it again, cherry-picked information put up there for anyone to take and use, and thereby avoid the undertakings that we're all under. And in terms of cherry picking, it is selective what's in the material. There have been some media releases that have been released by government. They're not referred to. They say some different things. But the participants who choose to cite non-evidence don't choose to cite other non-evidence. And I'm not going to engage in that by myself referring to non-evidence. And picking up on what Mr. Leadham was saying, and Ms. Fong somewhat as well, which had to do with essentially saying that he or she had a difficult dilemma, what do I do, had to do something. didn't have the letter. Well, none of that explains or justifies counsel, who well know how to make argument and well know how to run hearings and proceedings from a counsel perspective. None of that justifies citing non-evidence. You just don't do that. There's a proper way to do things. Make an application for evidence and so forth, but you don't just stick it in and then start using it, especially in a selective way. Now, a couple of the council pointed out that you don't have the paragraphs in question before you. They're available, of course, and if we can be of any assistance to make them more easily available, we'd be happy to do that, but I'm assuming they're available through the commission. It certainly makes sense that you would want to look at the paragraphs in question in light of the submissions I've made and the other council have made, and that would be fine, but I don't accept that all of this can just be put off until sometime in December. You would need to, in my respectful submission, make a ruling on this before the material goes up on the website, and anything that does go on the website would have to be in accordance with whatever ruling you make. Thank you.
Mr. Commissioner, the Commission Council doesn't need to make submissions on the two sides. These have been adequately covered, but one thing I need some clarification from Mr. Taylor on is what exactly does he say is in breach of an undertaking? Because I've heard some of the council say that they have not released any information that was produced under the undertaking, and I've heard in reply Mr. Taylor say that there is a breach of undertaking, and I'd like him to identify what exactly he says is the breach of undertaking.
Well, I thought I was careful with my words, but let me try again. The concern I have is by putting stuff in submissions that is not evidence, you then allow people to have it on the website and make use of that in the public domain. It's a springboard, if you like, to having statements that are subject of undertaking, or material that's subject of undertaking, added on to what's already going out there. I'll have to, if it's important to do so, look at the paragraphs in question to parse out any particular words. But my concern is that they are referring to non-evidence, and that in turn will lead to some springboarding, if I could put it that way.
I would like some clarification on that, because if Mr. Taylor is saying that he's taken or the other parties have taken a media release that's public and referred to it in their submission, and then it gets put on the website and becomes public, well, it started in the public arena to begin with, so I'm not sure how that's an issue on undertakings. And that would be, I think, from the Commission's perspective, the one issue that we would want to weigh in on is if there is a breach of undertaking. Something was produced through the Commission process that's to be kept confidential until marked in these hearings. Obviously, we have a concern that that would not be put on as part of submissions. But if they're referring to media releases that are public in the first instance, I'm not sure that the issue of undertakings comes up, and the fact that they're then put on our submission with reference and again put into the public arena does not seem to be a concern.
I'll try again. I don't have the various media releases that were referred to in front of me, but one of them came from SFU, and it was related to a report that underlined that. And as I read the material, what was being said went beyond the actual release and into the underlying report. It's about non-evidence going into reply, and it's about doing that, in my view, wrongly, and at a time in particular when there is going to be an evidentiary hearing. So I hope that clarifies that we could deal with this motion without undertakings then.
And I thank Mr. Taylor for recanting, because I too take my professional obligations seriously. And I've never been subjected to anyone in a public forum or otherwise suggesting that I've been a breach of an undertaking. And I'm grateful to Mr. Taylor for withdrawing those comments, because I am personally offended by them. And that if he insists on taking this course, which I understand he may not, then I joined with Ms. Fong that we're entitled to know exactly how and what way simply referring to press releases is a breach of undertaking.
Mr. Commissioner, I think it would be a benefit if we have some ground rules on how the next week of hearings occurs, and in particular with respect to the ISAB issue. It's an important issue and it should be dealt with in a fulsome evidentiary record and in a proper manner. The province submits that during the course of these hearings that the submissions be on this point be not referred to, and as well that any oral submissions not address this point and deal with the evidentiary record at the time. And then in December, when we have the additional hearings, any further submissions then will address this particular point, because the province does submit it's a very important issue that needs to be dealt with properly and not done in a haphazard manner at this time. And those are my submissions.
Thank you, Mr. Commissioner. I think we probably need to wrap up this point. You've heard submissions on Mr. Taylor's motion. Ms. Callan has now suggested that the issue not be dealt with at all. On that point, I would simply say that Council have the time allotted to them for their reply submissions. They will have time to deal with ISA when we reconvene on that point, and it should be up to Council to decide how they want to treat the issue. They are all professionals, and they can decide the best way to address the issue, and I wouldn't put a restriction on how Council choose to spend their time during their limited reply submission at this point. That would be my submission.
Thank you very much. I hope this is on and you can hear me. Thank you to Mr. Taylor, Mr. Liam, Ms. Gartner, the province, and Ms. Fong, and anyone else who has risen on this point. Obviously, as Mr. Taylor pointed out, I have not looked at the reply submissions that Council have been referring to, and I would want to do that before I made any ruling, but I want to assure all Council that before the reply submissions that are being addressed would go on the website, I would give my ruling so that there's no further complications arising from concerns that any of the Council might have with respect to the content of those replies. So I don't intend to postpone this matter until December, as has been suggested, but I would like an opportunity to consider your submissions and to consider this material so I can make my ruling accordingly, and I will do that. So I think, Ms. Baker, for the moment, I will postpone making a ruling until I've had an opportunity to consider the submissions more fully, and that means that we could, if it's convenient for you and the rest of Council, launch into submissions this morning.
Thank you, Mr. Commissioner.
Thank you very much.
I'll move away from this chair in a moment, but I'll just introduce the first participant making submissions today will be Canada, and they have 180 minutes, so I anticipate they'll take up the bulk of the day, if not all the day.
Mitchell Taylor, with me is Tim Leadham, or the participant, Tim Timberg today. I have Mr. Leadham on the mind. We're going to finish today, I think, as was indicated. We have 3 hours. Under the old schedule, we might have spilled over till Monday, but I think there's still 3 hours left in today. Myself and Mr. Timberg will divide up the presentation of Canada's submissions. Mark East, one of our co-counsel, was also going to be making presentation, but just before we started, he seemed to have some serious back difficulty, and it looks like he won't be able to do that, so we'll fill in for his part. With that, the general division of topics will be, well, firstly, let me say and ask Mr. Commissioner, I hope you have before you a written copy of our final submission and of our reply. 2 documents. Thank you. The general, and of course we'll focus on the written submissions, but we may and will to some extent delve into the reply on specific matters. The general division of topics is going to be that I will start and I will deal with an overview and something of the sockeye life cycle, the DFO structure, the legal context, harvest management, catch monitoring, enforcement, and in a second go by me, and I'll explain that in a moment, disease and aquaculture. Mr. Leadham, I'm going to keep saying that, I can see. Mr. Timberg, for his part, is going to address the policy context in which sockeye is managed, Fraser sockeye is managed, and that includes the wild salmon policy, and commercial and recreational fisheries, and as well the science-based approach to working through the possible causes of decline and the 209 poor return. Mr. Timberg is then also going to address what Mr. East would have addressed, that is the Aboriginal issues. And I'm going to speak for 45 minutes, meaning till the bottom of the hour approximately, and Mr. Timberg will then pick up and go for probably an hour and 45 minutes, taking account of breaks, and then I will finish up sometime this afternoon with about 30 minutes, which that all should add up to 3 hours. Now, before I begin, I just want to deal with a process point that's been raised by the Aquaculture Coalition in its final submissions, the ones filed on October the 17th, and by the Conservation Coalition in its reply just now. And happily, I think, it's less controversial than the matter I raised before, and I'm not asking you for a ruling at this time, so you'll be pleased with that, I'm sure. But at page 79 to 80 of the Aquaculture Coalition's final submissions, and at page 32 of the Conservation Coalition's reply, both of them suggest that the Commission ringtail, that is the very large database that's been accumulated over the last year plus, that Commission ringtail collection be made public following the conclusion of this Commission. I'm not going to make submissions on that here and now, but I want to say this. If the Commission were to contemplate taking up that suggestion by the Aquaculture Coalition and the Conservation Coalition, we would want an opportunity to make submissions first. And the reason is that to make public the document disclosure that's been done under compulsion, pursuant to the rules of this Commission, and in the case of Canada, an order that was made in June of 2010 at our invitation, that would constitute, in my submission, a fundamental upending of the ground rules on which document disclosure for this Commission has proceeded. It would also go against the normal rules of document disclosure, which of course, as you, Mr. Commissioner, will well know, is done on implied or actual undertakings of confidentiality in legal processes or proceedings. Exhibits are public, but the normal disclosure behind that is not. So I raise that issue and leave it for future submissions if called upon, if the Commission were to think of uptaking what has been suggested. And just on this in closing, I'll point out that the document disclosure in this Commission, to my chagrin and over my somewhat opposition, has been quite one-sided. There's approximately 550,000 documents that are in the Commission ringtail. Most of those, approximately 520,000, are from the Government of Canada. That is not to say they're all originally written by the Government of Canada, but from the Government of Canada files. And so the document disclosure, unlike a normal legal process, is overwhelmingly one-sided. The Commission chose not to take up my several requests to call for extensive documents from other participants. And so we have the one-sidedness that we do. And just finally, and this will be my final on this, the Commission ringtail database potentially contains privileged material. Given the short time frames for document disclosure, and as you can well appreciate, in normal litigation, hundreds of thousands of documents would be disclosed over the course of several years, not in the short time frame we've done. There's been an understanding that if inadvertently privileged material is disclosed, we can ask to have it hauled back, and that in fact has occurred on a number of occasions, and all of the participants in Commission Council have cooperated in that regard. So there's an added element, if you like, to just put everything out in the public domain would be potentially putting out privileged material in a context where there's an understanding that there'd be a haulback opportunity. And that was put in place simply because it wasn't feasible to vet the stuff with sufficient detail in the time available to get the material to the Commission so they could then use most of it, as you know, roughly or almost 2,000 documents of the 550,000 have become exhibits. So I leave that at this point. To the submissions on the merits of the evidence that is before you, Mr. Commissioner, Canada's intent, and I want to be clear in this, Canada's intent in its written material, the final submissions that were filed on October 17th, and in the reply filed on November 3rd, is to provide you, Mr. Commissioner, with a balanced and comprehensive statement of what we consider to be significant evidence on key topics. We're fully aware that you, Mr. Commissioner, and the officials in your commission will study the written material of Canada and the other participants in depth in the coming weeks and months as part of the process leading to the final report. In these oral submissions, we'll speak to what we consider to be particularly important points within each of the topics covered in our written material, and in some cases expand or explain what is in the written material. In the written material and the oral submissions, we do not, and it is our intent anyhow, to not advocate for or against any given position, nor do we make recommendations or comment on other people's recommendations. The federal government, of course, commissioned this inquiry, appointing you as the commissioner, and we view that recommendations are something for the federal government to receive after due deliberation by you, and not something that we're going to suggest. We leave that process with you. And as I say, our objective is to assist the Commission, and specifically you, Mr. Commissioner, by first having contributed to ensure that there is a comprehensive evidentiary record, both viva voce evidence and documentary exhibits, and secondly, to point to what in our view is the truly important pieces of evidence. We do consider that the participation of each and every participant has greatly contributed to the making of a comprehensive evidentiary record before you, and we see value in the numerous different perspectives that have been brought before you, Mr. Commissioner, and will, over the next week or so, be brought before you for consideration. I've already spoken to the number of documents that we have produced. But in addition, there's been tens of witnesses, I think something in the order of 80 witnesses who are federal employees, mainly but not exclusively from the Department of Fisheries and Oceans. The Department of Environment had some witnesses, and I think there was one or two other departments as well. Next, a brief word on the terms of reference. You, of course, will be well familiar that this commission was established to inquire into and make findings of fact regarding the cause of decline of Fraser sockeye, the current state of Fraser sockeye and long-term projections, and then to develop recommendations for improving the future sustainability of the Fraser sockeye. It's a broad mandate as it concerns Fraser sockeye. So it's narrow in the sense of the topic, Fraser sockeye, but broad in terms of what you are mandated to do with respect to Fraser sockeye. Because Fraser sockeye don't live in isolation, they live in a habitat that is impacted by many activities and many organizations and governments, and because other species also live in that same habitat, both aquatic and animals, land animals, use it as well. There are many parts to this puzzle, and it's a complex task that has been given to you, Mr. Commissioner, and one that everyone will no doubt benefit from the ultimate report. The Commission is to conduct the inquiry with the overall aim of encouraging broad cooperation among stakeholders, and that is something that the Department of Fisheries witnesses have given a lot of evidence on, and something which the Fisheries Department and the Government of Canada endorse, both as it pertains to this Commission of Inquiry and pertains to the management of the fishery generally. You will have heard a lot of evidence about the efforts and resources and time and money that fisheries puts into stakeholder engagement and cooperation amongst and with stakeholders. We believe that the overall aim of encouraging broad cooperation amongst stakeholders has been accomplished by this Commission. There are a number of processes this Commission has employed, from public forums to site visits to public submissions on your website, and as well the evidentiary hearings, which these submissions are the end product of. And it is, in my submission, the case that participants have all pulled together to assist this Commission in understanding what are the truly important issues and evidence to put before you. There are differing views, of course, but that's to be expected. There are some areas where some people have concurrent or consistent views, and there's even some areas where virtually everyone, I think, has the same view, and the foremost amongst that is that while we have different objectives, or different participants have different objectives and ways to get there, a robust, healthy fish stock is a common objective of everyone, I think. This Commission, under the terms of reference, is to be conducted without seeking to find fault on the part of any individual, community, or organization, and we believe that too has been accomplished. So, what do the participants bring to the inquiry? I want to speak to that a little bit more. I've spoken what the inquiry is about, but in a nutshell, what happened to cause the decline, what's the current state, and here's the important part looking forward, what should be done to ensure things are put right and put on an upward curve. Every participant, as I've suggested, has put their heart and soul and mind into the inquiry and brought their own perspective, their own interests, and what they consider to be the truly important things before you. There's been suggestions put forward how to build a good and proper fisheries regime to best manage and conserve fish stocks and the fishery generally. Some ideas fit with others, some conflict, some are doable quite easily, others are not so doable, others are very costly or complex to implement. You, of course, will have to sift through and sort out the wheat from the chaff and decide what you think is the true facts and the most important things to recommend. No doubt about it, there's great complexity and differing interests in play. In a way, Mr. Commissioner, you're put in the position and you can see the challenge that the fisheries managers have. You, if you like, are not managing the fishery, but at the same time, you are being asked to make findings and make recommendations on how to manage the fishery. It's, of course, very clear that the sockeye salmon life cycle and their associated biology is very complex. It's complex biologically, and it's complicated because you can't see the fish most of the time. You see them, if you like, at the beginning and near the end for the most part, and not in between. There's a lot that's not known about that in-between time, both as to the fish and what they're doing and the impactors that are upon them. Now, we see the following themes as the key to improving the future sustainability of the Fraser Sockeye. And this is not an exhaustive list, but it's some things that I'm going to leave with you for your consideration, Mr. Commissioner. And some of these things we'll pick up on and speak to in some more detail as we go through the oral submissions, and they're addressed in the written material too. They are not necessarily in a given order, but the first couple or three I think are the most important. They are conservation, biodiversity, sound science, consultation, balance in what's done, sustainable fisheries, managing in the face of uncertainty and in the face of changing environmental conditions. And next, incremental steps lead to thoughtful and thought-through change. And lastly, for now, again, this is not an exhaustive list, but lastly, for now, look at the big picture, or put otherwise, look long down the field. One can sometimes look 2 feet in front of oneself, so to speak, and miss what's important because you're looking at the immediate. But it's important to look long down the field. And as part of looking at the big picture, and while it's of course always to mind, it's not necessarily to the front of one's mind, and there really hasn't been much evidence about this next point in this inquiry, but it's important to remember that the Fraser Sockeye aren't the only fish in the sea. There's an awful lot of other marine species, fish and marine mammals and crustaceans and any number of life in the sea. And there's of course all kinds of plant life. But it is important to remember that they aren't the only fish in the sea, and what you do for one can impact the other. Mostly conservation and biodiversity and habitat protection. I should have mentioned that one in the above, habitat protection. Mostly what you do for any species will be of benefit to the other, but it's not always the case. One other thing to remember in the context of the Fraser Sockeye not being the only fish in the sea is that there are many others, and quite a number of them are not doing so well either, and that includes salmonids. That would be the case not only in British Columbia waters, but in the waters of other countries. And it is also the case that we really haven't heard too much evidence about what is going on in other countries with respect to salmon or sockeye or any other species. We've heard a little bit about Alaska, and there's the odd whiff of Washington State, but not too much. Now, DFO organization and budgets. I want to spend a few moments on that at pages 14 through 23, which of course I leave with you. But I want to speak to a few key points about DFO organization and budgets. First, I want to talk about science, and I'm now using science as big S, science branch, as opposed to the subject matter science. A key message that I want to leave with you, Mr. Commissioner, is that DFO is a science-based organization. That is fundamental in my submission to understanding DFO. Science is the underpinning to pretty much everything DFO does in relation to fisheries management and conservation. There will be some aspects that will not be heavily science dependent, of course, but science is fundamental to most. Some enforcement activities and so forth probably don't have a lot of science to them, but science is the underpinning to what DFO does. And you've heard a lot of evidence that DFO, and in particular DFO managers, place great importance on scientific research and scientific advice in making decisions. It's one element to the decision-making process, but it's a very, very important piece of the puzzle and very important element. You've heard that loud and clear. as I have seen in my submission, as I've seen the evidence unfold. Science, like other sectors in DFO and other government departments, set short and long-term priorities. They do that annually, semi-annually actually, in terms of the process, and it's a recurring process each year. The priorities that are set are reflective of both government priorities and resources and conservation needs. But in setting priorities, science and the scientists in them and the science managers act, I say the evidence shows, in an objective, professional manner, reflecting what they believe within the budgets available to them are the truly important things to do for the better understanding of the sockeye salmon and other species, and for the better ability to advise fisheries managers in what they need to know to manage the fishery. I'll speak about budgets now, and any part of the government is impacted by the current need to tighten and be efficient with money. And that's, of course, not peculiar to the federal government or government generally. It is the fact that any organization, government, industry, non-government organizations, and so forth, are particularly challenged in the present economic climate. It's always going to be the case that there are a finite amount of funds, and not everything can be done, and not as much of what you do can always be done as would be ideal. And that's even more so right now. Prioritizing and being efficient with resources and money and technology are key ingredients. They're increasingly important, and a key point I want to underline for you, if I may. Suggestions and recommendations that involve large financial outlays would, I believe, need to meet a fairly high threshold of need. There may be a need, but the more you're talking about, the higher the threshold is probably going to be. And that's simply reality. There have been submissions made by some participants about DFO's budget as it's affected by strategic review. That's the process that has recently been completed by DFO and is about to be implemented, but the numbers are known. As with many things, people can come up with different numbers depending on how they want to present the numbers. But there was, towards the end of the final panel that the Deputy Minister was testifying in, along with Mr. Bevan and Ms. Farlinger and Dr. Richards, a question that, as I recall, both the Deputy and Mr. Bevan were speaking to, where between myself and Mr. Buchanan for the participant PSAC, evidence about what DFO has undergone for strategic review. Bottom line, it's in the budget that was tabled in the House June 6th of this year, I think it is. $56.8 million over 3 years, that is in stages, is cut. A total of $56.8 million is cut from DFO's budget. They run on about 1.8 or so billion dollars a year, 1.7, something like that. It was a 3% cut. They testified to that. It's not 25%, it's not 30%, it's not 50%, as some participants would want to suggest. It's a significant cut. It is a reality, but the deputy said it's doable, and importantly, it has to be done, and will be done. There's a further process that's now starting. We don't know where that's going to go. It's called Strategic and Operating Review, slightly different name, but it's again reflective of the need by the federal government to address expenses and look at what's being done everywhere and prioritize things. At the moment, people are simply being asked to produce scenarios for 5 or 10% cuts. It's not known what the outcome will be. That will happen over the course of the next number of months, as I understand it. That's the evidence. Coming back to DFO and its structure, DFO is a highly decentralized and operational department. That is to say, most of the department's resources work in regions. The evidence is approximately 85% of the 11,000 staff work in regions, and most of those staff are in operations. And we deal with that at paragraph 71 of our final submissions. DFO interfaces with other federal departments, other governments, stakeholders, First Nations, environmental organizations, industry, and others regularly. You're going to hear more from Mr. Timberg on the processes that provide for First Nation consultation, using the word consultation in the Haida Taku sense, and you're going to hear from Mr. Timberg some more about consultation that's done as part of good governance and management of the fisheries and engagement with stakeholders. For now, what I want to underline is that while DFO has the lead responsibility for fish conservation and fish management, it's not the only agency, person, or organization who have responsibility. There's a complex web of interactions of different people, and everyone has roles and responsibilities, and that does need to be remembered in my submission in plotting and setting out recommendations. For DFO's part, it works and liaises alongside with many other agencies. That's just part of how they do business. It is, of course, the case that the province have significant chunks of jurisdiction over matters that bear on fish and fish habitat. The legal context, I want to spend a few moments on that. Function does not extend to adjudicating on legal issues. We review the legal context applicable to fish and fisheries management in and around pages 25 to 51 of our final submissions. But I want to underline the point that in our submission, it's not the function of this commission to delve deeply into the legal context, but still the evidence needs to be situated against the legal environment. While some participants seemingly urge you to engage in and address and potentially even adjudicate on legal issues, that's not something for the Commission, for you, Mr. Commissioner, in our submission to do in this forum. We address this in Canada's reply at paragraphs Canada's reply paragraphs 3 to 8. That is to say that this is not about adjudicating on legal issues, and I leave that with you. What the inquiry is about, of course, is to investigate issues or events, and that is the general role of an inquiry. There's, of course, nothing in the terms of reference that would mandate the Commission to reach conclusions of law. The participants, and Mr. Timberg will speak to this, but the participants that I particularly have to mind is that participant number 12, Area G, Mr. Harvey's counsel, has a number of legal propositions that are of dubious validity in our submission that he wants to advance. And some of the First Nation participants make representations and invite some conclusions as to the law on Aboriginal fishing. Now, applicable laws and jurisprudence. I'm not going to delve into the law, of course, as I've said, but I do point out that there are a multitude of federal, provincial, municipal, and First Nation laws that bear on fish habitat. And in addition, there are international treaties, not only, but notably the Pacific Salmon Treaty, and that itself is subject of a PPR, a Policy and Practice Report. I think it's Policy and Practice Report number 4. There are common law principles and jurisprudence on fishing by the public and on Aboriginal fishing. It can be a complicated area in terms of Aboriginal law. One of the benefits I find of Aboriginal law is ultimately there's about 25 Supreme Court of Canada cases that you need to know, and if you do, you know most of what the law is. If you look at those cases, you will see that the law is evolving in Aboriginal law, and in particular Aboriginal fisheries law, and a lot of the Aboriginal cases come out of British Columbia, and a lot of those are fishing cases. And the law is not so evolving, but still there is some evolving aspects about it to do with fishing by the public. We set out some of that in our submission, but again, it's not for you. It's not because we're asking you to make findings on the law, but rather to simply provide some context. DFO has as a tool, as one of the things in its toolkit, Section 35 of the Fisheries Act. And there is also Section 36, which is administered by the Department of Environment. Those are powerful tools. I'm just going to pause for a moment. Started at 1:45. Yeah. Just doing a time check, sorry, Mr. Commissioner. Those are powerful tools, and it's important that you have a close look at the evidence pertaining to them. One of the things about Section 36 has to do with who should administer it, and you will need to make, you will reach conclusions about what you think in that regard. There's considerable evidence before you. There's currently, as I think you've heard in evidence, some consideration about that. And no doubt what you have to say would be welcome as a further piece of information and suggestion how that should be accomplished. The laws pertaining to habitat protection and environmental issues can be a thorny one in many ways, but one of the ways that they can be thorny is from a jurisdictional standpoint. The environment is not an enumerated area of jurisdiction in the Constitution Act 1867. Each of the federal and provincial governments are going to have some jurisdiction over environmental matters. That's led to considerable litigation and then jurisprudence over the course of the last few decades. But for the moment, it's important to remember that because each of the federal and provincial governments have a role, one has to always be mindful as to how far any one government can go on its own with regard to environmental matters, which brings me back to Section 35 in particular, but 35 and 36, which are grounded, if you like, in or anchored in fish and fish habitat, and that is used as the federal jurisdiction. I'm going to move to some areas that are near the back of our final submissions. So I've skipped over some sections that Mr. Timberg is going to speak to, and in about 10 minutes, in exactly 10 minutes, I will turn the podium over to Mr. Timberg, and then I will come back to some of this as I pick up towards the end, leaving it for Mr. Timberg to carry on probably after the break. Mr. Commissioner, I'm alive to the time. Am I okay to go for 10 minutes, or do you want me to stop for 15?
I can check, Mr. Chair, if you want to carry on for 10 minutes.
Yeah, that's okay. I'm now, just for your reference, I'm not asking you to turn this up, but for your reference, I'm towards the back of our submissions at page 165, which starts paragraph 563 and following. And it's under a heading of clear rules for sharing the Fraser sockeye harvest, including more flexible approaches to avoid weak stocks, address First Nation fishery aspirations, and improve the economic viability of the commercial fishery. So I'm now, if you like, jumping ahead, and I'm at the point where this is after Mr. Timberg, if you like, has spoken to some of the detail about some of these things. That is, avoiding fishing on mixed stocks and overfishing the weak stocks, and addressing First Nation fishery issues and the economic viability of the commercial fishery. So now I'm speaking about clear rules for that. And I'll take a few moments to start in on this, just in terms of efficient use of time, if you like, before the break, and then give Mr. Timberg an uninterrupted go after that. Clear rules for quantifying and sharing the available harvesting opportunities are important very important in my submission, to reduce conflict, provide certainty for business planning, and promote collaboration amongst harvesters. Change is in the air and in the water, so to speak, and that's driven by conservation needs and biodiversity, and by environmental change, First Nations Section 35 rights to food fish, food social ceremonial fishing that is, and the desire to put more fisheries closer to their natal streams to reduce fishing on mixed stocks. And there's various demonstration fisheries in that regard that we'll come to later. But in an atmosphere of change, which can be disconcerting, of course, any change can be, it's important to have clear rules. Starting in the 1990s or so, the DFO New Directions policy set out what might be considered modern allocation principles. Mr. Timberg is going to speak to some of that. But for now, the 7 principles of fisheries allocation are at paragraph 570 of Canada's final submissions. Again, I don't need to take you to it, but I'll leave it with you for later use. But the 7 principles are conservation, then for allocation. First, conservation has to be dealt with or met. And then you have First Nation food social ceremonial. The next or third principle in fisheries allocation is that the common property nature of the resource is respected. And so, fourthly, after conservation and First Nation FSC, there is the recreational fishery, and fifthly, the commercial fishery. Those 2 things, recreational and commercial, are on an even footing. It's not that one's higher than the other. And then a 6th principle of fisheries allocation is encouraging selective fishing. And finally, the 7th, to adjust the split between the gillnet, the seine, and the troll over time to better reflect how each of those gear types deal with conservation requirements and selectivity in fishing through changes to gear types. The integrated fisheries management plans represent clear implementation rules and at the same time offer transparency in fisheries management, and that's to be encouraged. It is also the case, and this is a point that I want to underline, that DFO considers, and it is right in my submission, that change in fisheries management is best done incrementally and in a consultative, transparent way. Those 3 words are words that DFO are very important to DFO. Incremental, consultative, and transparency. Because no matter what the activity is, if things are done incrementally, as I said before, that means they are well thought through, or can be well thought through. And if they're done consultative, you have potential and opportunity, and it is DFO's objective for buy-in, because those you are consulting with will be part of the solution. And if it's done in a transparent way, everyone can understand what is happening, even if you don't necessarily agree with it. So incremental, consultative, and transparent is done so as to bring stakeholders along. And at the same time, it allows everyone to see how something's working before it becomes entrenched. One could add to this, do things in a demonstration or pilot sort of way before you make it permanent. If something works well through those approaches and meets conservation and user group needs, then there's likely going to be acceptance. And if it doesn't, further change can occur. And that, in part, is what's behind share-based fisheries and demonstration fisheries in river that you'll hear some more about from ourselves and from other participants. Doing things in a demonstration or pilot or test sort of way also allows the feasibility and practicality to be tested and figured out before things become too entrenched. And on share-based fisheries in particular, there's been some positive results and some concerns expressed from some quarters, and those positive sides and concerns can be studied and adjustments made. And we deal with some of the demonstration fisheries and the particulars of those at paragraphs 588 and following. Another area where confidence and trust amongst all parties is important is in the in-season management of the fishery. And we deal with that at pages 176 through 178. You've heard a lot of evidence on some of the key programs and facilities for in-season management, but they of course include the test fisheries, the hydroacoustic estimates, admission and at Quailark, and the stock composition information that comes from biological sampling. All of that's needed. All of it should continue, of course. It's important pieces of information for managing the fishery, in addition to the pre-season work that is done, and you've heard evidence about that as well. In terms of this, that is in-season management and other areas, it's important going forward that there be increased use of technology, including increased use of technology over resource-intensive measures. That's the way forward in the 21st century. And what technology can offer, of course, is even more accuracy than you otherwise would have, and it can offer efficiency and ease with which to gather information. It's, of course, important that you have technology that has databases, and good databases underline it, and databases that can talk to each other. So, as I indicated, Mr. Commissioner, I'm currently in the back part of the submissions. There's a whole chunk from about page 50 to about page 150 that Mr. Timberg, formerly Mr. Timberg and Mr. East, but now Mr. Timberg will speak to over the next roughly hour and 45 minutes. And I propose that following the adjournment, if that, or the break, if that be the case now, that Mr. Timberg take the podium and we'll carry on.
Thank you.
The hearing will now recess for 15 minutes.